Is there a benefit to having a will and a ladybird deed as a backup? So I want to clarify one thing about a will. I have this in other videos, but this is a common misconception. A will or a last will and testament does nothing to keep your assets out of probate. I'm going to say that one more time. A will does not keep your assets out of probate. So what a will is designed to do is actually the opposite. It's designed to give direction to the probate judge as to where you want your assets to go after all creditors are paid and other things that need to be handled in the estate during the probate process are handled. So a will by itself is often not a good idea at all, because your assets are going to be going through probate. What does prevent probate, assuming your beneficiaries are alive and well, is putting beneficiaries or TODs, transfer on death, POD, payable on death, designations on everything you own, all of your assets. The way to do this with a home in Florida, and yes, these are permitted in Texas, because I know the same person who commented here also asked about Texas. So if you live in Florida or Texas, there is a way that you can actually put beneficiaries on the title to your home. Again, in Florida, we call these enhanced life estate deeds, or more commonly known as ladybird deeds. If you list one or more beneficiaries on a ladybird deed, often called a remainderman, then that remainderman will have title to the property after the last surviving owner passes away without it needing to go through a probate process. So in my opinion, if you're going to choose one or the other, or you can only do one or the other, ditch the will. Put beneficiaries on all your assets, and also put a beneficiary on your home using a ladybird deed or a transfer on death deed, which I believe Texas might refer to them as a transfer on death. I don't practice in Texas, so don't hold me to it, but I know they do have a similar deed to Florida in this regard. Your beneficiary designations on your home or on your accounts would trump a will anyway. Doesn't matter what your will says, your beneficiary designations control. So if you want to keep assets out of probate, put beneficiaries on them. Make sure if your beneficiary passes away before you or becomes disabled, you remove them. And if they're disabled, you speak to an attorney. If they pass away, you can change the beneficiary to someone else. If they become disabled, you need to talk to an attorney, because receiving an inheritance could mess with any government benefits they have. But short of that, if you make sure that you have a live and well and healthy beneficiary on everything you own, including your home, if allowed in your state, these assets won't have to go through probate. Okay, I hope this answers your question. And if there's any other questions regarding ladybird deeds or probate, estate planning, asset protection, Medicaid, or anything else, and you're in Florida, please don't hesitate to contact our office. We're atCause Law Office, the non-stuffy attorneys, and the link is in my bio. Have a wonderful evening.